Your visa application has just been declined. It's the end of the world. Or is it? Hi, I'm Simon Laurent. I'm the principal of Laurent Law Barristers and Solicitors. We're a specialist New Zealand immigration firm working on the outskirts of Auckland City. Been in practice since 1996. We handle all types of New Zealand immigration matters, visas and appeals and so on, but our real biggest focus is on problem solving, and this is a topic of reconsiderations which falls squarely into that bracket. So returning to the visa decline, what I'm going to speak about is mostly directed to people who have applied for visas while in New Zealand and applying for a further visa. Later on, I'll talk a little bit about what people overseas can do, but mainly we'll be talking about people who are already in the country and have run into difficulty with their application. Now, you can only apply for a reconsideration of a declined visa application if you still have a visa of some kind. Now, in our experience, most people do still have a visa nowadays, owing to changes in the immigration policy in 2017, which mean that if your original visa has expired, you automatically go on to an interim visa. And an interim visa will continue to operate for 21 days after the decline of your main application. However, you only have 14 days in order to file a reconsideration. This is a statutory time limit. Immigration has no discretion to extend that time to receive a reconsideration. So it's important to act upon this situation, if you face it, as soon as possible. We would recommend that you seek professional assistance, because there may be ways in which you can argue the reconsideration that have not occurred to you. So what are the grounds for reconsideration? The first point to make is that you don't have to come up with something new in order to get a reconsideration on the table. It literally means that a request for reconsideration is for Immigration New Zealand to consider the case again, as if it had not been declined. And you also get to put the case to a different visa officer at the same grade or at a higher grade than the one who made the original decision. This can be an important point because there may be technical things that need to be argued which require someone with more experience to consider them. Now, there are a number of ways in which a reconsideration could be successful, and I'll go through several of those now. The first is that the visa officer looking at the case has misapplied the policy that they are supposed to use. This does sometimes happen, and can sometimes happen in a way that is not particularly obvious. For example, the policy that could be used may be out of date, may relate to a different class of visa application to the one that you have applied for. Secondly, and this is not uncommon, they may have ignored very relevant evidence which is actually in the body of the application or is in the material they received, and simply failed to look at it. And this is especially the case in cases that get more complicated. It's particularly important in the current situation New Zealand faces with the labour market and so on, following the COVID-19 lockdown and the changes to the labour market, which have created a focus on the part of government to favour local workers over migrant workers. This is for employer-assisted work visas, so that for example, if there is a claim that the employer is not financially able to pay an employee because of the changes to their earnings owing to a fall off in business post-COVID, then there may be material on file that actually establishes that the company is financially capable, and that is simply being overlooked. Another way, and this is a very important one, that a reconsideration can be launched, is that in making the decision, the visa officer failed to put to the client, the applicant, grounds for the decision which they used, which they did not put to the applicant prior to the decision itself. Now, there is a fundamental principle in administrative law called the right of reply, that is, or the right to be heard. And that means that if there is something prejudicial in your case, it needs to be put to you for comment before a decision is made. You need to be given a chance to speak to it, because it may not necessarily be obvious to you as a lay applicant that there is an issue that that needs to be looked at. There may be information that immigration has that you're not aware of, and they fail to put it in front of you first. So this is what is also called a breach of natural justice. And it is important in this situation to have a look at what's in the decision letter and the grounds used relied upon for this. And secondly, to look at what came before the decision. What letters or emails did immigration send? Did they flag something for you which you could have answered? And if they didn't, then there's a ground for reconsideration right in front of you. Then, as I said before, although you don't have to put new evidence forward for a reconsideration, the fact that you do have new evidence can also be really important. For example, in the case of a partnership or a partner-based work visa, it may be simply that you didn't give immigration enough evidence to satisfy them that the partnership was genuine or long-lasting. And getting more of that evidence together, structuring it properly, can make all the difference. Now let's talk about the situation for people who are overseas briefly. There is no right to request a reconsideration of a visa application made by someone who is outside New Zealand. However, although there's no legally binding policy about this, the policy instructions do state that if new and compelling evidence is brought forward, immigration may consider it, and that's a matter of discretion. So you need to have a fairly good case to put forward to get their attention. But it can happen. I do sound a warning, however, that because of the effective border closure in response to the COVID-19 pandemic, there is an additional obstacle to getting immigration to even have a look at such a request. Because the tendency would be to say, we're not going to let you in unless you have really good reasons why we should. Now, as I said before, we would recommend anyone looking at getting their case reconsidered to recommend that they get professional assistance. So what can we or another professional immigration advisor do? Well, our starting point is to assess whether there are any flaws in the decision-making process. And this comes back to things like the breach of natural justice, that is, failing to put something that's really prejudicial to the applicant before the decision is made. So we go into a fairly analytical assessment of the steps that took place, which led to the decline. Secondly, we will argue the law, if we need to, that surrounds the policy in order to make the decision. This can involve having a look at previous case law, although for temporary visas, and that's what we're talking about here, there is often not a great deal of legal precedent to rely upon. But we would look at the principles of fairness and natural justice that are a part of immigration instructions and see whether they've been applied properly. We'll also have a look at whether the policy that is meant to relate to your application has been misapplied, and this can be something of a technical exercise at times. We'll also consider whether there is new evidence that can be put forward that can turn the scales in the application. And furthermore, we find ourselves needing to push people and saying, you haven't given us enough. This is what we need. And so people find that in order to really mount a proper case, they'll need to provide more than they thought. And this is also where we come in. This is the sort of work we do week in, week out, dealing with cases like reconsiderations, which are not run-of-the-mill applications, but require something extra. And we like to think that we do bring something extra. If you or someone that you know is facing a visa decline, don't know what to do, or are not confident about getting success on reconsideration, then you need to talk to us. This is at Laurent Law. We can be reached through our website at www.laurentlaw.co.nz, or you can email me at slaurent@laurentlaw.co.nz. Thank you for your attention and all the best.